Welcome everyone, and thank you for making the time. Over the next hour, we're going to work through two federal developments that have landed on a lot of HR desks very fast this year, and honestly, created a fair bit of noise along with them. The first is the EEOC pulling its long-standing 1979 Affirmative Action Guidance. The second is the FTC's continued enforcement against overly broad non-competes. You've probably seen the headlines. What you may not have yet is a calm, practical plan for what to actually do on Monday morning. That's what this session is. I want to be clear about the framing from the very first slide. This is not a legal update readout. This is an HR implementation program. We're going to translate what changed at the federal level into concrete things your recruiters, your managers, your comp team, and your program owners do differently, and just as importantly, the many things they can keep doing exactly as they are. Before we go any further, please read the disclaimer on the screen with me, because it matters. This session is for compliance education only. It is not legal advice. Every organization's facts are different, and you should involve your own counsel before you change an affirmative action plan, a DEI program, a restrictive covenant agreement, or any legally sensitive policy. Think of today as giving you the map and the method. Your lawyers help you drive the specific route. Here's what you'll walk away with: a repeatable audit method, a continue, modify, stop framework for triaging every program, safer language for your managers and recruiters, a role-based way to review non-competes, and an implementation checklist you can work through at your own pace. This is built for a broad room: HR, talent acquisition, DEI, compensation, legal, employee relations, learning and development, and the business leaders who actually make these calls. So let's get into it. I want to start by naming the most common mistake I see, because avoiding it is half the value of today. When a change like this hits, the instinct is to treat it as a legal affairs headline, something the general counsel reads, files, and moves on from. That's the trap. Look at the left side of the slide, the legal update. The EEOC removed its 1979 Affirmative Action Guidance from the Code of Federal Regulations. The FTC keeps enforcing against overbroad non-competes, and your inbox fills with headlines, alerts, and a lot of "what does this actually mean for us?" questions. All true, but none of that by itself changes a single decision in your company. Now look at the right side, the HR operating risk. This is where the change actually becomes real. It becomes real the moment a recruiter reads a sourcing instruction. It becomes real in how you build diverse slates and write recruiter scripts. It shows up in promotions, succession planning, and leadership pipelines. It shows up in your DEI programs, your ERGs, and your fellowships. It's in your documentation, in how complaints get handled, and in how a manager talks in a calibration meeting. And it runs through your non-compete practices across every role. So here's the mental model for the whole session. Everything in that left column, the update, generates the exposure in the right column, your everyday operations. The Federal Register isn't where your risk lives. Your risk lives in routine HR practice. And that's good news, because routine practice is exactly what we know how to audit and fix. For the rest of today, the right-hand column is our work list. Let me set expectations with 6 concrete outcomes, and these map directly to the arc of the deck. First, you'll be able to explain the 2026 EEOC rescission in plain, HR-friendly terms, the kind of explanation you can give a nervous manager or a curious executive without a law degree in the room. Second, you'll understand what the old 1979 safe harbor actually did, because you can't judge what its removal means until you know what it provided. Third, you'll be able to spot the higher risk practices across hiring, promotion, ERGs, fellowships, and leadership programs that deserve a fresh look. Fourth, you'll apply a continue, modify, stop triage, which is a practical way to sort every program without panic. Fifth, you'll review non-competes through a role-based lens rather than a blanket one. And sixth, you'll build defensible documentation, fair, job-related decision records that hold up if anyone ever asks, why this person? One more thing. Each of these objectives is backed by one of the 8 handouts you'll get at the end. So you're not leaving with theory. You're leaving with working tools that operationalize every one of these 6 outcomes. If you take a screenshot of one slide today, make it this one. It's the entire webinar in a single frame. 2 independent federal moves pointing to the same HR response. On the EEOC side, the agency rescinded its 1979 Voluntary Affirmative Action Guidance. That's 29 CFR Part 1608, along with Section 607 of its compliance manual. What that removes is a long-standing federal reference point and a good faith safe harbor for plans that were conscious of protected traits. I'll say something in a moment that I'll keep repeating all day because it keeps us accurate. The underlying statute and the Supreme Court cases did not change. What changed is that the agency's shield is gone and its scrutiny is up. On the FTC side, having stepped back from a nationwide ban by rule, the agency is now enforcing case by case against broad boilerplate non-competes. The finalized Rollins/Orkin order is the flagship example. It freed more than 18,000 workers and signals real scrutiny of restrictions that can't be justified. And the unifying message is at the bottom. Audit now and shift your mindset from measuring demographic outcomes to controlling for fair, job-related, well-documented process. Audit hiring, promotion, development, pay, and your restrictive covenants. That single reframe, outcomes to process, is the thread that ties the 2 developments together. We'll hold the specifics for the slides that follow. This is the headline. Let me give you the through line, because the history makes everything after it easier to explain to your teams. 4 points on a timeline. 1964, Title VII of the Civil Rights Act. This is the anchor. It bans employment discrimination based on race, color, religion, sex, and national origin. Everything we discuss today ultimately traces back to that statute. 1979, the EEOC issued interpretive guidelines that encouraged employers, unions, and others to take voluntary affirmative action for minorities and women, and importantly, gave a measure of legal comfort to plans built on that guidance. Hold on to that word voluntary, because it defines what this guidance was and wasn't. Through the 1980s and into the 2020s, the courts increasingly framed Title VII as protecting every individual equally, regardless of group membership. This wasn't one dramatic moment. It was a gradual shift in emphasis over 4 decades. And then 2026, the EEOC concluded its 1979 guidance no longer matched that reading of the law and rescinded it, along with Section 607. So the honest way to describe this to your organization is that the ground shifted slowly, and 2026 is the formal catch-up, not a sudden, brand new prohibition that appeared out of nowhere. Now let's be precise about what employers actually had under that 1979 framework, because the word safe harbor can be misunderstood. Start with what it was, structurally. Part 1608 was interpretive guidance. The EEOC doesn't have the power to issue substantive Title VII regulations, so this was persuasive a strong reference point, but it was never binding law in the way a statute is. Keep that distinction handy. Its purpose, in the first row, was to encourage voluntary affirmative action under Title VII. Its focus, the second row, was improving employment opportunities for minorities and women. Its use, the third row, was as the basis for written voluntary affirmative action plans and structured programs. It was the blueprint employers pointed to when they built one of these plans. And the fourth row is the one people mean when they say safe harbor. Good faith reliance on the guidance could support a statutory defense under Section 713(b)(1). In plain terms, if you built a plan in reliance on the guidance, you could point to that reliance as a defense. I'll be candid. In practice, that specific defense was rarely invoked, but the framework still functioned as a reference point and, frankly, a comfort factor for a lot of programs. That reference point and that comfort is what disappeared in 2026. Here are the everyday practices that grew up on or around that old framework. And I want you to look at this slide as a preview of exactly what we're going to audit later. Voluntary affirmative action plans. Written plans structured under the guidance. Diverse slate policies. Rules requiring some representation in the candidate pool. Conscious outreach. Race or sex-conscious sourcing efforts. Leadership pipelines. Development tracks aimed at specific groups. Fellowships and internships with eligibility tied to demographics. And remedial programs designed to correct an identified workforce imbalance. Here's the important tone to strike with your own people. Most of these were adopted with genuinely good intentions. Nobody built a diverse slate rule to break the law. They built it to widen opportunity. So the message is not, everything on this slide is now illegal. The message is that each of these now deserves a fresh look, because the federal reference point that lent them comfort has been withdrawn. Some will continue untouched. Some will be modified. A narrow set will need to pause. That triage is the work, and we'll get there systematically. Let me keep this one very precise, because precision here is what keeps you from overstating the change to your leadership. Before, employers could point to the EEOC's 1979 guidance and Section 607 as a federal reference, and in principle as a good faith safe harbor. After, that guidance is rescinded and removed from the agency's framework. The Federal Register rule is effective July 2026, following the agency's action earlier that summer, and the HR impact in the third column. There is now less federal agency support for decisions that turn on a protected trait. Programs have to stand on current law rather than on withdrawn guidance. Now, read the bottom bar with me, because this is the single most important sentence on the slide. The law didn't change. The federal safe harbor did. Title VII is intact. Supreme Court precedent is intact. What's gone is the EEOC's roadmap and that good faith defense. If a manager or an executive asks you, is affirmative action illegal now? This is your answer. The statute you've always operated under is exactly the same. What you've lost is an agency's endorsement and a defensive cushion. That distinction keeps everyone calm and keeps you accurate. Whether or not you agree with the agency's reasoning, it's useful to understand it, because understanding the why helps you plan around it. The EEOC gave 4 reasons, and I'll present them straight, without editorializing. First, inconsistency with the text of Title VII. The agency's position is that the 1979 guidance conflicts with the statute's protection of every individual. Second, it contradicts later precedent. It's out of step with how the Supreme Court and lower courts have developed the law over the intervening decades. Third, it's simply obsolete. The 1979 context, the agency argues, no longer reflects current law or the current workplace. And fourth, it was one-directional. It contemplated only plans that benefit women and minorities, which the agency views as offering less protection to majority group employees. You don't have to litigate whether these 4 points are right to do your job well. Your job is to notice the direction of travel and adjust your practices accordingly. So take this as the stated basis for the change, and let's move to what it means operationally, which is really the heart of the next slide. I promise not to give you a constitutional law lecture. You don't need one, and I'd lose half the room. But there's one legal signal worth understanding because it drives everything downstream. The court principle on the left is a single idea. Title VII protects every individual equally. And the guidance points to a recent example, Ames versus Ohio Department of Youth Services, decided in 2025, which confirmed that so-called majority group or reverse discrimination plaintiffs are not held to a higher evidentiary bar than anyone else. In practical terms, that means a claim from a majority group employee is evaluated on the same footing as any other discrimination claim. The middle tile is the EEOC action. The agency aligned its guidance with that reading by rescinding the 1979 framework. So the courtroom trend and the agency move are pointing the same direction. And the right tile is the part you actually operationalize the HR meaning. Design your employment decisions around individuals and job-related criteria, not group membership. That's the whole translation. Whether it's a hire, a promotion, a development opportunity, or a pay decision, build it on what the individual brings to the specific job, and make sure you could defend it without ever mentioning which group they belong to. That is the bridge from the courtroom to your everyday process, and it's a bridge we'll keep crossing for the rest of the session. This slide exists to prevent panic and to keep us accurate, which matters just as much. Because in the weeks after a change like this, myths spread fast, and overcorrection can do as much harm as the original risk. Let's clear the myths one by one. DEI is banned. No, equal opportunity and inclusion work can continue. You can't train on bias anymore. No, anti-discrimination training can continue. Stop all outreach. No, broad outreach to widen your candidate pool can continue. Pay equity is off limits. No, pay equity analysis can continue, and it's actually a recommended discipline. Inclusive culture is illegal. No, inclusive culture work can continue. So what is the real issue? It's the line at the bottom. Don't use protected traits as the deciding factor in employment decisions. That's the whole thing in one sentence. The risk isn't inclusion. The risk is narrower and more specific, using race, sex, national origin, and the like as the operative factor in a selection, an eligibility rule, a hire, a promotion, a training seat, a fellowship, a leadership slot, a pay decision, or access to a program. So here's the pivot for the rest of the day. We are not here to dismantle inclusion. We're here to find and fix those specific decision points where a protected trait is doing the deciding. Reassure your people of that loudly and early, because a workforce that thinks inclusion is canceled will create its own set of problems. Here's the core HR problem in one picture. And I chose the word quietly on purpose. Almost no organization has a written policy that says, use race or sex to decide. If it were that obvious, you'd have fixed it years ago. The exposure is subtler than that. It lives inside routine practices across the employee lifecycle. How you source and slate candidates, how you set eligibility for development programs and fellowships, how managers talk in calibration, how you make pay decisions, and who gets access to the career-enhancing programs. Look at the band across the slide. The first stage, attract, is broad outreach, and that's generally the safe zone. Casting a wide net is lawful and encouraged. But notice where the navy highlighting concentrates. Hire, develop, promote, pay, and access. Those are the decision points where a protected trait can actually influence an outcome. And those are where our attention belongs. The line at the bottom says it plainly. Everyday practices, slate rules, eligibility criteria, calibration talk, pay decisions, program access are exactly where trait-conscious factors slip in. Not through malice usually, through habit, and through well-intentioned shortcuts. So, for the rest of the deck, we're going to walk each of these decision points and install neutral, job-related controls, one stage at a time. Before we get into the audit mechanics, I want to make one point emphatically. This is a cross-functional program, not an HR-only cleanup. If HR tries to do this alone, it will fail, because HR doesn't make most of the decisions that create the exposure. Let me walk the table at a brisk pace so everyone sees their lane. HR leadership owns program risk and governance. So the immediate action is to launch the audit. HR business partners advise the business on daily decisions. They're your front line, so they coach managers on criteria. Talent acquisition runs sourcing, slates, and scripts. That's the highest volume risk surface in the building, so they review recruiting inputs. DEI and inclusion own programs and eligibility. They review access and eligibility rules. Compensation sets pay and promotion rationale. They anchor decisions to legitimate factors. Legal and compliance own exposure and defense. They review the high-risk programs. Employee relations handles complaints. They prepare to field reverse bias claims. Learning and development runs the development tracks. They open eligibility criteria. Business leaders and managers make and voice the decisions. They commit to job-related criteria only. And HRIS and People Analytics supply the demographic data. Their job is to wall that data off from individual selection. Everyone in that list has a specific role. The next slide turns each of these into a concrete first-week action, so nobody leaves wondering what they personally own. Let's turn that awareness into a one-week action list. The things each function can start on immediately, without waiting for a big project charter. HR leadership. Launch the audit and set the governance and timeline. Give this an owner and a deadline, or it drifts. Talent acquisition and recruiters. Review the 3 highest volume inputs, sourcing instructions, slate rules, and recruiter scripts. DEI. Review program access and eligibility rules. Compensation. Re-anchor your pay and promotion rationale to legitimate factors: role, skills, tenure, performance, market, scope. Legal. Take the high-risk programs and the restrictive covenants. Business leaders. Stop quota and preference language immediately. And I want to flag that one because it's the single, fastest, free, same-day fix on this entire slide. It costs nothing, and it removes some of your sharpest exposure. Managers. Use job-related criteria and document their decisions as they make them. And people analytics. Separate demographic data from selection. Keep the dashboards for aggregate insight, out of the individual decision. None of these require a consultant or a budget request to begin. They're this week's work. And the implementation checklist near the end pulls all of it together into something you can work through at whatever pace fits your organization. This is the operational spine of the entire program. So this is the slide I want you to linger on, and honestly, the one to bring back to your leadership. It answers the question everyone's really asking: what do we keep, what do we change, and what do we stop? And it does it without drama. Look at the continue column first, because it's the biggest one, and that's the point. Equal opportunity commitments, anti-discrimination training, structured interviews, broad outreach, pay equity review, and inclusive culture work all proceed. Most of what a good HR function does lands here and doesn't change at all. Start with that message. It lowers the temperature in the room. The modify column is where the real work sits. Diverse slate rules, DEI hiring goals, fellowship eligibility, leadership programs, ERG membership rules, promotion dashboards. Notice, none of these are stop. They can usually survive and keep serving their mission if you redesign them around neutral, job-related criteria and open access. Modification is the answer far more often than elimination. And the stop or pause column is deliberately short and sharp. Quotas, trait-based selection, exclusive career access, manager targets tied to race or sex, using demographic data as a selection factor. These are the practices with no good redesign they need to pause now. Here's the rule of thumb I'd tattoo on this program. When in doubt, modify with counsel, rather than defaulting to stop. Reflexively shutting things down looks decisive, but it damages morale and often isn't required. Thoughtful modification is usually both lawful and better for your people. Language is the cheapest and fastest fix you have, and if you get it wrong, it's also the easiest evidence to create against yourself. So this slide earns its place. On the left are phrasings that genuinely show up in requisitions, in emails, in meeting notes. We need to hire a woman for this role. Only minority candidates should be considered. This leadership track is only for women. Every one of those targets an outcome by protected trait, and every one reads, on a printed page in front of an investigator, as intent to prefer or exclude. That's the problem, not the goal behind it, but the words chosen to express it. On the right is the reframe, and here's the key insight. The business goal doesn't change. You still want a strong, diverse pool and a fair process. You just express it through outreach and job-related criteria. Source broadly and evaluate all qualified candidates using job-related criteria. Eligibility is based on role readiness, performance, skills, and development goals. Same intent, widen opportunity, choose the best person, expressed in language that defends you instead of exposing you. Teach your managers and recruiters this exact swap, explicitly, because these phrases surface in discovery. The single principle to leave them with. Describe the process and the criteria, never the demographic result you want. Your manager do/don't language sheet and your recruiter safe language guide give them the full phrasebook, so they're not improvising. Now we start the audit itself, function by function, and we begin with recruiting, because it's the highest volume risk surface in your organization. Every day, at scale, decisions get made here. So we audit it end to end, from the top of the funnel to the offer. Start with job postings. Strip out demographic targeting and preferred identity language. Move to recruiter scripts and talking points, and to sourcing instructions. This is where the quiet phrase, "Find me more diverse candidates before we move forward," lives. And it's exactly the kind of instruction that becomes a problem. Diverse slate rules get flagged for redesign. And I'll say it again because people mishear it. Broad outreach is fine. A demographic quota on the finalist pool is the issue. Then screening and knockout criteria. Every one of them should be job-related and defensible. Interview scorecards and rubrics should measure competencies, not some vague notion of fit that maps onto demographics. And don't forget the last line, vendor and search firm instructions. What you put in writing to an external recruiter is your liability, just as much as an internal script. If you told a search firm to deliver a demographically shaped slate, that instruction has your company's name on it. The hiring and diverse slate review checklist walks every one of these checkpoints, so your TA team has a structured pass rather than a vibe check. Promotions and succession carry a quieter risk than hiring, but in some ways a sharper one. And here's why. These decisions get made in rooms, with notes taken, and with witnesses present. Everything said in that room can later become evidence. Audit the promotion and readiness criteria first. They should be written down and job-related, not living only in a manager's head. Then the 9-box grids and calibration notes. This is the danger zone. A comment like, "We need more women at this level," captured in the calibration notes, turns your talent grid into a document that argues against you. Succession dashboards should be built on performance, scope, and readiness, not demographic balance. And manager comments the documented rationale for a move must connect clearly to skills and results. The line on the slide is the one to read aloud to your leaders. Calibration meetings and 9-box notes become discoverable evidence. Keep the record job-related. I've watched organizations run beautifully fair promotion processes and then undermine them with one careless sentence in the notes. Coach your leaders that the written record should read the way you'd want it read back to you in a deposition, grounded in performance and readiness, every time. The promotion documentation template gives them a clean, defensible format, so the good decision and the good record match. This is where good faith programs most often need modification rather than elimination. So this is a slide to deliver with reassurance, not alarm. The whole audit here reduces to one organizing question at the top. Is a career-enhancing benefit restricted by a protected trait? Run each program through 6 lenses. Eligibility. Who qualifies, and is it trait-based? Access. Is it open to all or restricted? Funding. Is the company subsidizing an advantage for some employees over others? Work time participation. Is this a paid on-the-clock benefit? Executive exposure. Does it give access to leaders and sponsors, the people who influence careers? And career-enhancing benefits. Promotion visibility, stretch roles, the things that actually move a career forward. Here's the logic. The more yes answers a program collects across those lenses, especially the career-enhancing ones, the more scrutiny it needs. A book club is low stakes. A funded, on-the-clock program that connects you to executives and puts you on the promotion radar is high stakes. And if that's gated by a protected trait, that's your exposure. But notice the fix is almost never to kill the program. It's to open eligibility and access using neutral criteria while preserving the mission. You keep the developmental purpose. You remove the trait-based gate. The ERG and Leadership Program Eligibility Checklist is your working tool for exactly this analysis. Compensation needs a careful, two-sided message, and I want you to deliver both sides clearly, because getting only half of it causes real problems. First side, and say this unambiguously, pay equity analysis can and should continue. Studying whether similarly situated people are paid comparably is lawful, and it's good practice. Don't let anyone tell your comp team to shut that down. That would be an overcorrection. So where's the line? Look at the left panel. Base individual pay on legitimate factors. Role and scope, skills and credentials, tenure and experience, performance, market data, and documented business reasons. Those are the inputs that justify an individual's number. Now the right panel, what to avoid. Using demographic targets as a factor in an individual's pay. Adjusting a single person's pay to hit a representation number. And undocumented equity exceptions, those one-off adjustments that nobody wrote a reason for. The discipline here is subtle but crucial. Keep your aggregate equity analysis separate from your individual pay actions. Analyze patterns across the population. Decide individual pay on legitimate, documented factors. When you find a gap in the aggregate analysis, you investigate the legitimate reasons for it. You don't reach in and adjust one person's pay to a demographic number. That separation is what keeps a lawful, valuable practice from becoming a liability. Documentation is what converts a fair decision into a defensible one. And I want to reframe how your teams think about it, because most people experience documentation as bureaucracy, a tax on getting work done. It isn't. It's the record that answers the only question that matters when someone challenges the decision. Why this person? For every consequential employment decision, the file should show these 9 things. The job-related criteria you used, the candidate pool you considered, the interview rubric or evaluation method, the selection rationale, the promotion criteria where relevant, the compensation rationale, who the decision makers were, any exceptions and why they were made, and evidence of HR or legal review for the sensitive cases. The line on the slide is blunt on purpose. If it isn't written down, it didn't happen. For a hearing officer, a jury, or an investigator. A fair decision with no record is, from a defense standpoint, indistinguishable from an unfair one. Silence doesn't help you. And the one word I'd underline is contemporaneous. Build the record at the time you make the decision, not reconstructed 3 months later when a complaint arrives, because reconstructed documentation reads exactly like what it is. Your promotion documentation template and the audit checklists standardize this so it becomes a habit, not a scramble. Let me show you risk as an escalation, rather than a single event. Because understanding the latter tells you exactly where it's cheapest to intervene. At the wide base of the pyramid, everyday internal complaints. These are cheap to resolve when you catch them early, and expensive to ignore. Left unaddressed, they climb. The next tier up is EEOC charges and investigations. Above that, reverse bias and retaliation claims. And these are increasingly viable as courts apply that equal treatment reasoning we talked about earlier. Above that, lawsuits, settlements, and remedies like back pay and front pay. And at the very apex, compensatory and punitive damages. The financial headline nobody wants. Here's the takeaway for HR, and it's genuinely strategic. The cheapest place to stop this is the bottom of the pyramid. Good process, clean documentation, and prompt, serious complaint handling, long before anything reaches the tiers where lawyers and damages enter the picture. Every dollar and hour you invest at the base saves you enormous cost at the top. Most catastrophic outcomes started as an early complaint that somebody waved off. So treat the base of this pyramid as your highest leverage work. And let's quantify the top of it on the next slide. Let's quantify the top of that pyramid carefully and correct a very common myth in the same breath. The Title VII caps on combined compensatory and punitive damages scale with your headcount. 15 to 100 employees, $50,000. 101 to 200, $100,000. 201 to 500, $200,000. And 501 or more, $300,000. Those are the caps. Now look at the panel on the right, because this is where people underestimate their exposure. Those caps cover damages only. Separate and uncapped, back pay, front pay, lost benefits, attorney's fees, expert fees, and court costs. None of those are subject to the caps. That's precisely why real-world exposure so often exceeds the cap number. The cap is only one component of what a losing case actually costs. And here's the myth buster at the bottom, which I want you to carry back to any executive who's panicking. These are litigation exposure ranges, not automatic fines. There is no automatic penalty for having an outdated DEI policy sitting on a shelf. Liability flows from a proven violation in an actual case. So please keep 5 different things distinct in your own head and in your briefings. Direct penalties, litigation exposure, settlements, damages, and operational cost. They are not the same, and conflating them is how a manageable situation turns into needless panic. Here's a cost that never shows up in a legal memo, and in my experience, it's often the one that actually moves executives to act, because it hits the business directly even when no one ever files a charge. When guidance feels unclear, look at what happens around the wheel. Hiring slows down. Recruiters get confused and freeze, unsure what they're allowed to say. Managers make inconsistent calls, which generate their own crop of complaints. Organizations overcorrect and freeze DEI programs wholesale, which damages morale and momentum. Documentation quality degrades under the uncertainty. And there's reputation damage and employee trust loss on both sides of this. You'll have employees who feel excluded, and employees who feel programs were dismantled clumsily and without explanation. Both erode trust. So the message to your leadership is this: a clear, calm, well-communicated audit isn't just legal hygiene. It's what keeps your talent engine running, while everyone else in your industry is frozen and second-guessing. Ambiguity is itself a cost, arguably the biggest one on this slide. The organizations that handle this well won't be the ones that reacted fastest or loudest. They'll be the ones that moved deliberately and told their people what was happening. Clarity is a competitive advantage here. Everything we've covered needs a container, a method simple enough that people actually use it. So here's the one to remember. It spells FAIR, and it's 4 steps. F is find. Inventory the high-risk policies and programs across hiring, promotion, development, pay, and access. You can't audit what you haven't listed, and most organizations are surprised by how many programs surface once they actually make the list. A is assess. For each item, determine whether a protected trait actually influences a decision, an eligibility rule, or a benefit. This is where the decision tree and the risk matrix we're about to see come in. I is implement. Replace the trade-conscious factors with neutral, job-related criteria and open access. This is the redesign step, the modify work from our triage. R is record. Capture the documentation that shows the decision was fair and job-related. Close the loop with evidence. And here's the important part. FAIR is a cycle, not a one-time cleanup project. Every new program, every new requisition, every new fellowship re-enters at find. You're not trying to reach a finish line, you're installing a standing discipline. This framework anchors your DEI and affirmative action risk audit checklist, and it gives every function, TA, DEI, comp, legal, a shared vocabulary, so you're all describing the work the same way. Now, let me give your manager something they can run in about 90 seconds without a lawyer in the room. Because you cannot put legal on speed dial for every program in the company. This is a fast triage. 5 yes or no questions. 1. Does the program affect a real employment lever? Hiring, pay, promotion, training, or advancement? 2. Is eligibility based on a protected trait? 3. Are managers told to meet demographic outcomes? 4. Is demographic data used in selection? 5. Is access restricted by group? And the routing rule is beautifully simple. Any single yes sends the program to HR or legal review before it continues. Not kill it, escalate it. Get another set of eyes. Make the modify or pause call deliberately. Only an all-no program is lower risk. And even then, the instruction is document and proceed, not skip the paperwork. Why does this matter so much? Because you have dozens, maybe hundreds of managers making judgment calls, and consistency is what protects you. This tree keeps the judgment consistent across all of them, and it prevents the 2 failure modes at once: reckless approval on one end and reflexive, panicky shutdown on the other. Put this on a one-pager. It might be the single most used artifact from today. Once you've screened a program, you need to rate it so the organization knows what to fix first. Here's the rating scale. 4 levels, and I'll give you the tell for each. Low risk. The program is open to everyone and uses job-related criteria throughout. Most of your inclusion work lands here, and low means proceed and document. Medium. You conduct demographic outreach to widen the pool, but the actual selection stays neutral. That's acceptable. Monitor it, but you don't need to tear it down. Outreach to widen the funnel is not the same as selecting on a trait. High. A protected trait influences eligibility or access. This one needs modification and legal review. It's not automatically unlawful, but it's carrying real exposure and can't stay as is. And critical. Quotas, explicit preferences, exclusion, or a manager instruction tied to a protected class. That's pause immediately and remediate with counsel territory. The practical instruction is straightforward. Rate every program on your audit checklist using this scale. Then work the critical and high items first. Don't let a team spend 3 weeks perfecting a low-rated book club while a critical-rated selection practice keeps running. Triage by severity, exactly like you would in any risk discipline. This matrix is how you turn a long, overwhelming inventory into a prioritized, finite work list. Now, let's make all of this concrete, because frameworks click when you see them applied. We'll work through 6 real-world scenarios. This first one is the single most common finding in real audits, so you'll likely recognize it. The situation. A company requires every final slate to include at least one woman and one minority candidate. Familiar, right? And the intent is genuinely good. Widen the pool. Make sure diverse candidates get seen. The risk is in the mechanism, not the goal. A hard requirement that a finalist slate contains specific demographics can force a qualified candidate to be delayed or bumped so the rule is satisfied. And that exclusion, one identifiable person passed over to meet a demographic requirement, is exactly what a reverse discrimination complaint is built from. The good intention doesn't neutralize the mechanism. The HR fix keeps the goal and changes the method. Replace the demographic slate mandate with broad outreach, plus consistent job-related screening applied to every candidate. Invest heavily, really heavily in outreach, so the pool is genuinely wide at the top. Then screen everyone with the same criteria. Outreach is lawful and encouraged. A demographic gate on the finalist pool is the risk. So the exercise for your team is simple. Go pull your own slate policy and rewrite it this way. If it mandates a demographic composition of finalists, that's the sentence that has to change. Scenario 2 moves us to leadership development programs. And this one tests whether you've internalized the career-enhancing benefit idea from the program audit. The situation. A program offers executive mentoring and promotion visibility, but only women may join. The tell here is that the program delivers real advancement currency. This isn't a social group, it's executive access, sponsorship, and a spot on the promotion radar. The risk. Because the benefit is genuinely career-enhancing, restricting membership by sex means a male employee can claim exclusion from an opportunity tied directly to advancement. And under the equal treatment reasoning we discussed, that's precisely the kind of claim the courts now take seriously. The HR fix, again, is not to kill the program. Open the career-enhancing benefits to all eligible employees using neutral criteria: readiness, performance, aspiration to leadership, while preserving the development mission. Here's the nuance worth stating out loud to your teams. You can still emphasize outreach to underrepresented groups. You can still design content that speaks to the barriers those groups face. What you can't do is lock the door by trait. Keep the mission, keep the outreach, remove the eligibility gate. That's the pattern for almost every program in this category. Scenario 3 raises the stakes, because now money is involved. The situation. A paid fellowship is restricted to applicants of certain racial or ethnic groups. And the fact that it's paid matters. This is a real job benefit, compensation, not a volunteer opportunity. The risk? Because it's compensated and career-enhancing, a rejected applicant has a clean, direct path to an EEOC charge, alleging exclusion based on a protected characteristic. There's a specific person who applied, was told no, and can point to the reason. That's about as clear a fact pattern as exists. The HR fix is to redesign eligibility around neutral criteria. And here's the practical insight that surprises people. You can often reach very similar populations without ever using a protected trait. Think first-generation college status, demonstrated economic disadvantage, partnerships with specific schools, geography, career interest, and skills or readiness. These are neutral gates that frequently correlate with the communities the program was designed to serve. But they're job and circumstance-based, not trait-based. One caution I'll emphasize. Notice the words "after legal review" on the slide. Neutral criteria design is genuinely nuanced and fact-specific. Some proxies can themselves draw scrutiny, so this is a place where you partner with counsel rather than improvise. But the headline is encouraging. This is a modify, not a stop. The fellowship survives with a lawful gate. Scenario 4 is the one that happens live, in the room, and it's the one your HR business partners most need a script for, because it unfolds in real time and there's no pause button unless someone presses it. This situation. In a calibration meeting, a leader says, "We need to promote a woman this cycle." Said casually, probably with good intent, maybe even in response to a real representation gap. But it's now been said, in a room, with witnesses. The risk. Those meeting notes and those witnesses become evidence of a trait-based promotion decision. A single sentence can anchor an entire claim because it reframes whatever decision follows as driven by sex rather than merit, whether or not that's actually what happened. The HR fix has to be immediate. Pause the conversation and redirect to the legitimate factors: performance, scope, readiness, skills, documented criteria, and business need. And then correct the record on the spot, so the written notes reflect the job-related basis, not the demographic aside. Here's the coaching point for your HRBPs. Do this without embarrassing the leader. You don't scold them. You say something like, "Let's ground that in readiness and scope. Who's demonstrably ready for this level?" You've redirected the conversation to defensible territory and protected the leader at the same time. Your manager do/don't sheet gives them those words, so they're not caught flat-footed in the moment. Scenario 5 is the ERG question, and I want to handle this one gently because it makes people anxious, and the honest answer is more reassuring than they expect. Let me say it plainly first. ERGs are valuable, and they're generally fine. Nothing today is an argument against employee resource groups. So where does risk actually appear? Look at the situation. An employer-funded ERG offers executive access and networking, but restricts membership by group. The risk shows up only in that specific combination, when an employer-funded ERG becomes a channel for advancement currency, and then restricts who's allowed to walk through that door. The risk? An employee claims exclusion from an advancement opportunity that the employer is funding. If the benefit is career enhancing and the gate is a protected trait, an excluded employee has a claim. And the HR fix preserves the ERG entirely. Open membership and events to all employees, including allies, while keeping the group's mission, identity, and community focus completely intact. This is the crucial nuance. You're not diluting the ERG or erasing its purpose. A women's network can still be a women's network in spirit and focus. It simply welcomes anyone who wants to support that mission, and it doesn't lock high-value career access behind a trait. You keep the belonging. You remove the exclusive career gate. The ERG participation model in your eligibility checklist shows exactly how to draw that line. Let's shift to the second federal thread, non-competes. And I have to start by correcting a misconception, because a lot of employers drew exactly the wrong conclusion. Here's the wrong conclusion. The FTC tried to ban non-competes. The ban failed in court, so we're in the clear. Look at the left tile. It's half true. The nationwide ban by rule was blocked in court. The FTC dropped its appeal, and that rule never took effect. So if you were waiting for a blanket federal ban, it didn't happen. But look at the right tile, because this is what most people missed. The agency didn't retreat, it pivoted. It now enforces case by case against specific employers under Section 5 of the FTC Act, focusing on broad boilerplate non-competes that limit worker mobility and competition, especially for lower-level workers. And here's the part I really want to land, on the bottom bar. The ban is gone, but the scrutiny is not. In some ways, targeted enforcement is a bigger deal for the average employer than a blanket rule would have been. A blanket rule would have been fought in court for years. Targeted enforcement is happening now against named companies, and it zeroes in on the exact pattern many employers have. Broad non-competes applied to workers who have no genuine trade secrets to protect. So, the ban failed is not a reason to relax. The next slide shows you precisely what this looks like in practice. Let's make the enforcement risk concrete with the flagship case, because a real example lands harder than any principle. On June 22, 2026, the FTC finalized a consent order against Rollins Incorporated, the parent company of Orkin, the pest control business. Look at the four numbers because they tell the whole story. More than 18,000 employees freed from non-competes nationwide, a typical restriction of 2 years post-employment, a 75-mile radius measured from any of Rollins's 700-plus U.S. locations, which, when you do the math, covers an enormous share of the country. And the order required notice to current and former employees, telling them they're free to compete. But the line at the bottom is the heart of it. These agreements applied broadly, including technicians, customer service reps, and other lower-wage roles with little negotiating power. That's the problem. This wasn't a narrow restriction on a few senior executives with access to real trade secrets. It was a sweeping boilerplate restriction imposed on frontline workers who had no meaningful ability to negotiate, and in most cases, nothing proprietary to protect. So preview the lesson we'll draw next. The issue wasn't that Rollins used non-competes at all. The issue was breadth and boilerplate. The same agreement applied to everyone, regardless of role, regardless of whether there was any legitimate interest to protect. That's the pattern regulators target, and it's a pattern that exists in a lot of companies that have never thought of themselves as at risk. Let's make the enforcement risk concrete with the flagship case, because a real example lands harder than any principle. On June 22, 2026, the FTC finalized a consent order against Rollins Incorporated, the parent company of Orkin, the pest control business. Look at the four numbers because they tell the whole story. More than 18,000 employees freed from non-competes nationwide, a typical restriction of 2 years post-employment, a 75-mile radius measured from any of Rollins's 700-plus U.S. locations, which, when you do the math, covers an enormous share of the country. And the order required notice to current and former employees, telling them they're free to compete. But the line at the bottom is the heart of it. These agreements applied broadly, including technicians, customer service reps, and other lower-wage roles with little negotiating power. That's the problem. This wasn't a narrow restriction on a few senior executives with access to real trade secrets. It was a sweeping boilerplate restriction imposed on frontline workers who had no meaningful ability to negotiate, and in most cases, nothing proprietary to protect. So preview the lesson we'll draw next. The issue wasn't that Rollins used non-competes at all. The issue was breadth and boilerplate. The same agreement applied to everyone, regardless of role, regardless of whether there was any legitimate interest to protect. That's the pattern regulators target, and it's a pattern that exists in a lot of companies that have never thought of themselves as at risk. Scenario 6 mirrors the Rollins case deliberately, so you can spot your own version of it before a regulator does. The situation: a company requires customer service reps, junior technicians, and sales trainees to sign 2-year non-competes. If that made anyone in the room shift a little uncomfortably, that's the point. This pattern is everywhere. The risk: this is regulatory challenge, employee complaints, recruiting harm, and retention problems all at once. The exact Rollins fact pattern. Broad, boilerplate, and untethered to any genuine trade secret or customer relationship risk. And notice, the risk isn't only regulatory, it's practical. These agreements generate complaints. They worsen your candidate experience. Good people decline offers when they see a heavy non-compete for an entry-level job. And they create retention friction because people who feel trapped disengage. The HR fix is role-based tailoring. Limit non-competes to the roles with real business justification and protect your legitimate interests everywhere else with narrower tools, confidentiality, and non-solicitation agreements. So the action item is direct. Go look at who in your organization is currently signing non-competes. If frontline, lower leverage employees are signing 2-year restrictions, that's your Rollins exposure, sitting in your own filing cabinet. The role-based covenant decision tree in your matrix handout walks you through which roles genuinely warrant a restriction and which don't. Let's pause and make this personal for a moment. I'd like to run a quick poll because it re-energizes the room, and honestly, it tells me where to spend our Q&A time. Here's the question. Which area creates the highest risk in your organization right now? Your options: A. Hiring and diverse slates. B. Promotions and succession. C. DEI leadership programs. D. ERGs, fellowships and mentoring. E. Non-competes. F. Manager communications. Take a moment and vote. There's no wrong answer here. The value is in self-diagnosing before we do the group exercise. While the votes come in, let me point you to where each answer maps in what we've covered, so you know where to go afterward. If you picked hiring and slates, revisit the recruiting audit. Promotions. The promotion and succession audit. DEI programs. The program audit. ERGs and fellowships. The program audit and scenario 5. Non-competes. The redesign method and the 2 non-compete scenarios. And manager communications. The language slide and the calibration scenario. Whatever's winning on your screen right now is probably where you should start your own audit on Monday. Hold that thought. We're about to put it to work. Let's apply everything to one realistic scenario together. If you're in a room, break into small groups for 5 to 7 minutes. If you're remote, use the chat or just think it through with me. Here's the scenario. A recruiter is told to hold off until we get more diverse candidates, while a qualified candidate is ready to move forward. This is a composite of situations that happen constantly. Work through the 4 questions on the slide. First, what's the risk? Delaying or disadvantaging a ready, qualified candidate because of a demographic goal is a classic reverse discrimination and process integrity problem. And the instruction itself, hold off until we get more diverse candidates, is discoverable. It's sitting in an email or a chat thread right now. Second, what should HR stop? The hold until diverse instruction as a gating mechanism. That specific practice, pausing a qualified candidate to engineer the demographics of the pool, has to go. Third, what should HR modify? Convert it into intensified outreach that runs in parallel. You can absolutely push hard to widen the pool, as long as you don't pause qualified candidates to do it. Both things can happen at once. And fourth, what documentation is needed? The job-related criteria, the timeline, the decision rationale, and the outreach steps you took. Take a few minutes, then we'll debrief, and you'll notice every answer maps straight back to the continue, modify, stop framework. That's the point. Once the framework is in your hands, novel situations stop being scary. Let's close the loop with a practical way to actually do this work. Because a webinar that ends in inspiration but no plan just becomes a nice memory. So rather than hand you a rigid 30, 60, 90-day calendar, I've put everything on one checklist. And that's deliberate, because in the real world, organizations move at very different speeds. A 200-person company with a handful of programs can work through this in a few weeks. A global enterprise with dozens of programs, works councils, and multiple jurisdictions might reasonably take a couple of quarters. A fixed calendar sets most teams up to either feel behind or rush the parts that need care. A checklist doesn't. You work through it at whatever pace is realistic for you. Let me walk you the 12 items, because they follow a natural order. Start by inventorying all your programs and agreements. You can't manage what you haven't listed, and most organizations are surprised by how long that list gets. Flag the high-risk language. Pause the truly critical practices, the quotas and preferences we rated critical earlier, and review your recruiter and manager scripts. Those first 4 are your containment moves. For a lot of organizations, most of the urgent risk reduction happens right there. Then the redesign work. Rewrite deflagged policies. Review those changes with legal counsel. Train your recruiters and managers on the new language and criteria. And rework your ERGs, fellowships, and leadership programs around neutral criteria. This is the heavy lifting, the modify work from our triage, done deliberately rather than reactively. And it's the part you don't want to rush. And then you make it stick. Roll out the documentation templates. Complete the role-based non-compete review. Audit a sample of recent decisions to test whether your new controls are actually holding up in practice. And stand up ongoing complaint monitoring and governance. So this becomes a standing discipline rather than a one-time cleanup that quietly decays the moment attention moves on. Now, read the bar at the bottom with me, because it's the single most important instruction on the slide. Work through these at your own pace, but start with your critical and high-risk items first. The checklist reads top to bottom, but severity drives the real order of operations. If a critical program surfaces on day 1, you act on it on day 1. You don't wait until you've ticked every earlier box. Let the risk rating tell you what to grab first. And here's the good news that ties the whole day together. Your 8 handouts map straight onto this checklist, so nobody starts from a blank page. The containment items lean on the audit checklist and the language sheet. The redesign items lean on the eligibility checklists and the templates. The sustain items lean on the documentation template and the non-compete matrix. The tools already exist for every line on this list. You just set the pace that's realistic for your organization. If you forget everything else, take these 5 things, because these are what let you brief your own executives accurately in about 2 minutes without overstating or understating anything. 1. This is an implementation issue. The legal update is the trigger, but the response is operational, and HR owns it. It's not something to hand back to legal and forget. 2. DEI is not banned. What's high risk is specifically using protected traits as the operative factor in employment decisions. Hold that line against both the panickers and the deniers. 3. Shift from outcomes to process. Move from measuring demographic targets to controlling for fair, job-related process. That single reframe resolves most of the hard cases. 4. Documentation is critical. Fair, job-related, and written down is what actually defends a decision when it's challenged. An undocumented fair decision won't save you. And 5. Non-competes must be role-based. Narrowly justify each restriction and use lighter alternatives, confidentiality and non-solicit agreements, wherever a full non-compete isn't warranted. 5 sentences. If your people leave with just these, they can walk into any leadership conversation and represent this accurately, and they can start the audit with confidence rather than fear. Let me close on purpose and on tone, because how you frame this to your organization matters as much as what you do. The goal here was never to abandon equal opportunity. Read the slide with me. It's to redesign HR practices so they hold up. Make your hiring, promotion, development, compensation, and restrictive covenant decisions fair, job-related, documented, and legally defensible. That framing protects 2 things at once. It protects the organization from exposure, and it protects the people in it. Because fair, transparent, job-related processes are genuinely better for employees, not just safer for employers. Those 2 goals aren't in tension. Done well, they're the same goal. And you're not leaving empty-handed. Your toolkit is 8 handouts that turn today into action. The risk audit checklist, the hiring and diverse slate review, the promotion documentation template, the ERG and leadership eligibility checklist, the recruiter safe language guide, the non-compete role-based review matrix, the implementation checklist, and the manager do/don't language sheet. Every framework we discussed today has a corresponding tool in that set. Let me read our disclaimer one final time, because it's exactly as true now as it was at the start. This session is compliance education, not legal advice. Please consult your own counsel before you change any affirmative action plan, DEI program, restrictive covenant, or sensitive policy. With that, let's open it up for questions. I want to hear where your organizations are on this and where you're getting stuck.